last Friday's Lunch and Learn, which due to the Thanksgiving holiday is not actually being held on the last Friday of the month, but we kept the name since third Friday of November. Lunch and Learn just didn't have the same ring to it. My name is Kathryn Barry. I'm an attorney at Jackson Lewis, and we are very happy to be partnering with SHRM Long Island in offering this monthly quick-fire webinar series. I know some of you are probably getting a little bit tired of talking about the election, and it does feel like we've been talking about it forever at this point. But I hope you'll bear with us for just a little bit longer, because we did want to spend our time today giving a quick breakdown of the workplace law changes we think employers can expect in a Trump administration. Personal political feelings aside, the transition from an Obama administration to a Trump administration is very much a changing of the guard. When preparing for the election, at least at the end, we looked at the polls and we, like many other people, anticipated a Clinton presidency. And what we told employers was, if Clinton won, it likely would have been a continuation of the Obama-era policies and practices that we've lived and experienced over the past 8 years. It really wouldn't have been much of a change in that regard. But I think it's safe to say that Mr. Trump's approach to federal workplace law and the enforcement of federal workplace law will look very different and is very likely to change the landscape that employers are all operating in. It's important for all of you on the call today to understand and anticipate some of those changes so you can be best prepared to respond to them, because, and we'll walk through the big changes that we expect to see. Some of them will result in an easing back of enforcement, but in some areas you might see increased enforcement and maybe some additional responsibilities that didn't previously exist. Mr. Trump's approach to the enforcement of federal employment law is certainly going to be reflected in the makeup of the Supreme Court. Since the death of Justice Antonin Scalia, the Supreme Court has been operating with 8 justices. So we've been seeing split 4-4 decisions on a number of big issues. Following Justice Scalia's death, President Obama nominated Judge Merrick Garland, which would have changed the political makeup of the court from a Republican majority to a Democrat majority. The Senate, however, did not confirm Judge Garland, or has not confirmed Judge Garland to date, and it's unlikely that they will do so before the end of President Obama's time in the White House. So it seems safe to say that we will have a Republican majority on the Supreme Court deciding a number of significant employment issues, including whether collective action waivers in arbitration agreements violate the National Labor Relations Act. In addition to appointing a justice to fill the vacancy on the Supreme Court, Mr. Trump will have significant opportunity to fill a vast number of vacancies across the federal judiciary, both at the district court and the appellate court level. And for many employers, those appointments have more of an effect on your day-to-day employment litigations. We might see a shift from appointees who were usually more ideologically aligned with President Obama to just judges on the bench who are more ideologically aligned with Mr. Trump. I know we have spent so much time over the past 8 years talking about the rise of the National Labor Relations Board and the board's aggressive enforcement of employee rights against both union and non-union employers. So for all of you who have been wishing and hoping for us to just shut up about the NLRB already, you actually may get your wish. With 2 vacancies on the board, the National Labor Relations Board is likely going to shift from, like the Supreme Court, a Democrat majority to a Republican one. And with that shift in makeup, we can expect the board to revisit some of their previous more controversial decisions, including their decisions on class action waivers and their position that including class action waivers in arbitration agreements is a violation of the National Labor Relations Act, their expansive approach to defining joint employment and joint employment between companies, their approach to mixed bargaining units, and their decision that employees of a temporary staffing agency and permanent employees of an employer can be members of the same bargaining unit when those employers are joint employers. The quickie election rule that we spent a lot of time over the past year or so discussing, as well as really restricting what has been a significant expansion and a significant really open attempt by the board to expand what's considered protected concerted activity under the NLRA. And this is the belief that the board is going to shift their enforcement techniques is pretty much going to be consistent for, at least a consistent position for all of the federal enforcement agencies. I think we can expect an overall step back in terms of federal agencies' enforcement of anti-discrimination laws. So for those of you who have dealt with the EEOC or the OFCCP over the past 8 years, you know that their investigation of perceived discrimination, particularly perceived systemic discrimination, has been aggressive. I don't know for sure, but an educated guess leads us to believe that we will see a shift to more conservative enforcement practices and likely some attendant reductions in budget. For federal contractors and subcontractors, so those who have been dealing with the OFCCP over the past 8 years, when the OFCCP has been getting sort of consistently increased budgets and has taken a far more aggressive approach towards enforcement than it did in administrations prior, it's again safe to say that you might see a decrease in the length and depth of your average audit, your average compliance review. The Affordable Care Act, more commonly known as Obamacare, very well might be repealed or replaced given the Republicans control both Congress and the White House. So it's important to note that Mr. Trump has promised to keep some of the more popular aspects of the Affordable Care Act, including the requirements that children can be covered under their parents' health plan up to the age of 26, and the provisions which prohibit excluding coverage based on pre-existing conditions. This has been the question we've been seeing, I think, most frequently since Mr. Trump's election, which is what's going to happen with the new final rule on the salary basis that is set to go into effect just around the corner now on December 1st. At present, there is no indication that the salary basis regulations will be repealed or replaced. It's not to say that it won't happen, but we certainly can't say that it will at this point, and the rule will go into effect on December 1st as intended. What we might see is future legislation either phasing in the new salary basis, so that's going to be very difficult for them to do after it's already gone into effect, or more likely addressing the automatic 3-year increases in the salary basis amount. Understand that even if we do see some type of repeal or rescindment of the salary basis regulations, that's going to be a very complicated thing for employers to step back from. If you've increased employees' salaries as a result of the final rule, you know that it's hard to turn around and then take that increase back. Also, something to keep in mind, as all of you on the call are employers in New York, any change to the final rule on the salary basis will not affect the minimum wage orders in New York, setting their minimum levels for the salary basis and their minimum levels for hourly wages. We may see a comeback in the Department of Labor's previous practice of issuing official opinion letters regarding the FLSA. And those official opinion letters were really helpful for employers because they were usually very specific to a particular issue, and employers could rely on those opinion letters in making decisions about the application of the FLSA to its workplace, and its reliance could be, and an employer's reliance could be a defense to a future claim. During the Obama administration, the Department of Labor really stopped the practice of issuing official opinion letters, and they replaced official opinion letters with quote-unquote administrator interpretations that were much more broad. So I think we might see a return both to the practice of official opinion letters, and we also might see a change to the administrator interpretations that were issued during the Obama administration, particularly the administrator interpretations on joint employment and independent contractor status. As you may remember, both of those administrator interpretations, consistent with the Obama administration's approach to these issues as a whole, took a very, very broad stroke approach to when entities may be considered joint employers, and a very broad approach to what's the definition of an employee under the FLSA, essentially stating that under the DOL's position at the time, most individuals who were classified as independent contractors were misclassified. We could see those administrator interpretations being withdrawn and signaling a big change in opinion over at the DOL. There are ongoing challenges to a number of OSHA rules in the federal courts right now, including challenges to OSHA's electronic record keeping rule, which includes a non-retaliation provision that affects employers' ability to conduct automatic post-accident drug testing. As a result of the change in administration, it's likely that we could see the challenges to those OSHA rules result in settlements that lessen the regulatory impact of the rules. Also, we could see a rollback of the Department of Labor's fiduciary rule, expanding the definition of who's considered a fiduciary under both ERISA and the Internal Revenue Code. During the Obama administration, President Obama used executive orders to achieve a lot of the goals that his administration wanted to achieve but couldn't achieve because of the Republican Congress. So things like prohibiting discrimination against LGBT individuals by federal contractors, or increasing the minimum wage for federal contractors. Mr. Trump has stated publicly that he intends to undo all of President Obama's executive orders on his first day in office. So this could be an end to a number of those executive orders that have been applying to federal contractors and subcontractors over the past 8 years. It could also be the end of the Fair Play and Safe Workplace executive order, which requires certain reporting requirements for federal contractors and subcontractors and includes certain pay transparency provisions. And it could be the end of Executive Order 13706, which requires sick leave for federal contractors. Another important thing to note, though, like the final rule, the sick leave for federal contractors goes into effect on January 1st, before Mr. Trump will actually assume office. So anybody who is subject to that final rule will need to comply with the rule up until it is actually rescinded. We spoke about this for those of you who were at the October breakfast series, but just a couple of weeks ago, the EEOC finalized the changes to the annual EEO-1 pay data reporting. So the annual EEO-1 pay data reporting is a report that all employers with 100 or more employees need to file every year. Typically, that report has had to be filed in September. The changes to the EEO-1 report are requiring for the first time that employers report W-2 wages and hours worked for all of their employees, broken out by EEO-1 category, by race, and by sex. This is really a significant burden on employers to be able to collect and report that data, but has also been a significant area of concern for employers, as both the EEOC and the OFCCP have stated that they intended to use the EEO-1 pay reports in order to identify and essentially target those employers who they want to investigate for systemic pay discrimination or systemic pay practices. There's been a lot of outcry from the employer community because of the burden and because of the concern about how the information is going to be used. The new EEO-1 pay report is not due to be filed, the first one, until March of 2018. So it's very possible that before one of those reports needs to actually be filed with the EEOC, the Trump administration will either alter or rescind the changes to the EEO-1 report. Immigration was obviously a very hot topic during the campaign. We expect it to be a very significant area of focus for the Trump administration. For employers, that could mean a requirement that all employers use E-Verify as part of their onboarding and hiring practices. Currently, it's voluntary for non-federal contractors. We could see and expect a delay in individuals in high-risk countries or regions in obtaining visas, which might have an effect on your company's ability to get H-1B visas or get other employment-related visas for some of your workforce. And there could be overall reform to the H-1B visa program. Senator Jeff Sessions, who's a top Trump advisor, and this morning has been reported as going to be nominee for the Attorney General position, is a vocal critic of the current H-1B program. So we might see some changes or reform to the H-1B process. In terms of post-employment restrictions, the Department of Justice recently has taken the stance that employers who are agreeing amongst themselves to have sort of non-poach programs, and to some degree employers' use of non-compete agreements, can violate the law. We expect to see the DOJ easing back on their investigations or their potential criminal investigations of employers in the poaching context, and we expect that the new administration will likely not continue the current administration's attempts to prohibit the overbroad use of non-compete agreements. So as with all of the changes in enforcement we've been discussing, it's important to remember this only applies on the federal level. Here in New York, Attorney General Schneiderman has been very vocal about his opposition to the overuse of non-compete agreements, in his opinion, and we can likely continue to see attempts to curb the use of non-competes, at least on the state level. So really the key takeaways for all of you on the phone today is that things are going to change, and they're going to change pretty significantly. Some of those changes might make your day-to-day lives easier in terms of changes in enforcement practices, restrictions in budget for the enforcement agencies, rollbacks of some of the more onerous reporting requirements. Some might make your days a little bit harder if there are changes to the immigration program or if there is new required use of E-Verify. So it's important to stay on top of those changes and make sure that you're adapting your practices in your workplace as the changes come down. We will keep you up to date as a lot of this, which is very unknown, becomes more concrete, and as we do get more information about the administration's ideas and their intended practices in the employment law context. So really stay tuned. But thank you so much for joining the webinar today, and I hope everybody has a very happy Thanksgiving.